Hello, everyone. My name is Teresa McClenahan, Executive Director and Counsel at the Canadian Environmental Law Association. Thank you for joining us for this episode of Walkerton's Drinking Water Protection Legacy. In this series, we commemorate the 20th anniversary of the contamination of Walkerton's water supply by speaking with the people who experienced the tragedy and the inquiry that followed firsthand. With me today is Jim Merrit. Jim is a former Assistant Deputy Minister in the Ontario Government Ministry, involved in the early days of the Ontario Clean Water Agency. At the time of the inquiry, Jim agreed to provide guidance to the Selah legal team while we participated in phase one of the inquiry, which was focused on establishing the causal factors that led to the drinking water tragedy. Welcome, Jim.
Yes, hello, Teresa, and thank you very much for asking me to participate.
Thank you for joining us today, Jim. And it's been quite a few years before today that you and I have had a chance to speak, but we certainly did spend quite a bit of time working together at the time of the inquiry and afterward. So I have a few questions for you. The first is, why did you think it was important to assist the Selah team in advising and representing the concerned citizens of Walkerton during the inquiry?
Yes, thank you, Teresa. The Walkerton event and the tragedy that happened, I think, struck everybody who was in the drinking water business and functions at that time. I had actually retired from the Ministry of the Environment, but I'd felt very strongly about providing water to the public and safe drinking water. Water, I've always felt, and the provision of water is a trust, and it's a trust between those who operate those systems and assurance that they're going to provide safe water to their community. And to see this trust broken, I think is certainly a part of the tragedy overall. The interest in the inquiry, in addition, was when Selah asked me to participate in this. I felt very strongly that the community needed support, and so I was very pleased to hear that Selah was going to provide that support. The inquiry in part one, there were, as I understood it, 17 participants or officially recognized participants at the inquiry, only one of which was the public of Walkerton itself. And the other participants were certainly well supported. They were well financed. They had a lot of legal support. They had a lot of technical support. Mm-hmm. And I felt in participating that it was important that the citizens of Walkerton had the best support that we could provide. So I was very pleased to be able to work with the Selah team and provide that report and make sure that the people there were helped through the process. So that was really my driving interest.
Mm-hmm, mm-hmm. And I remember that your help was of great assistance to us at the time and to the citizens. So thinking back to your time working on the Walkerton inquiry, firstly during those phase one hearings, and then when you began advising Commissioner O'Connor in phase two, what stands out for you about that time?
Yeah, the phase one, it was certainly an interesting time. I didn't actually go to Walkerton and participate directly in the inquiry, but I worked with the Selah team, and it was a very interesting process to work through. Our responsibility was to receive these documents called will says every day during the days of the inquiry, and we would receive these documents in the late afternoon, pour through them, and often these were hundreds of pages of material to try and understand what the witnesses were going to say for that day and prepare the Selah legal counsel with the types of questions or the direction and understanding of what the content of those statements were going to be, and to try and come up with some questions that were going to be of assistance to the citizens. And so it was a very hectic time going through those documents, and then meeting late in the evening we didn't have the video conference. We just had telephone conferences at those times.
Mm-hmm.
Working through, Teresa, I remember working with you and Paul and others to try and develop these questions. And we knew we were only going to be allowed to have 2 or 3 questions at most. So you had to do the best you could with those particular witnesses, and understanding that everyone else was going to ask questions from different angles as well. And hopefully we could come up with digging out some of the best understandings from what was being said by all those technical people. So it was a very interesting and challenging time to go through that process. And I think it probably lasted 5 or 6 weeks was my recollection, but it may even been longer than that. And for a long time, I had masses of those will say documents piled up all over my home office.
Yes, I think it was many months actually, and you're right. The two of the Selah lawyers at a time would be up in Walkerton, and you and Faye de Leon from our office would have amassed all the documents back in Toronto, and then be sending faxes and couriers. Faye would, and you'd get on the phone with us or the rest of the legal team. So what about when you were advising Commissioner O'Connor in phase 2, what stands out for you about that?
Well, phase 2 was particularly interesting, and I was after phase 1 wrap up, I was surprised to get a request from the inquiry team. So I found myself on the other side of the table, actually sitting down with the inquiry counsel, preparing my own will say document, which turned out to be quite a considerable size, going through a number of the interests and questions that they had to try and explain the various roles within the ministry, and how the different offices and departments worked, and how they interreacted with municipalities and the various roles of with other ministries. So that was an interesting challenge, and I spent I think it was a day and a half on the stand going through that process, and had to face the questions from the 17 people that I was facing, and go through their challenges. But I found it was an interesting process. Subsequent to that, I got a call from Justice O'Connor, and he asked me if I would prepare a position paper. The inquiry had, I think, I put together 5 or 6 position papers on different topics, and he asked me to put together a position paper, particularly on that understanding of roles and responsibilities, because he said coming out of phase 1, they felt fairly strongly that there was a lot of confusion as to who thought they were doing what functions, and how those would and should all interrelate. So that was really the topic of my position paper.
And I remember that contribution was a pretty significant one, and all of Ontario thanks you for that, as well as the citizens. So from your perspective, thinking back now and thinking about what you were thinking about at the time, what were the most critical things to put in place to protect drinking water after the Walkerton tragedy occurred?
The key points to me, and going through the work with the inquiry, was several things needed to be cleared up. And the first one was understanding and making sure that the concept of mandatory compliance was put into place. Up till that Walkerton event, the ministry was really working on a voluntary basis. They encouraged municipalities, they encouraged other operators to do the best, to follow the guidelines, and clearly it wasn't working. But so the point about making those practices mandatory, to lay them out in law, to require that there be specific actions taken, and in fact that there were consequences for failure to take those actions, and those consequences were severe. I think that was a key point for me. The second thing that came out of this for me was, and something that I didn't wholly realize before the whole process of the inquiry, was terrific confusion as to roles and responsibilities, and particularly ownership. The question of ownership, who owned these systems, was really unclear. And it was quite clear from the testimony that people were looking to everyone else to figure out who was ultimately responsible. So it was very important that what came out of the part two was clear statements on the need for clearing up ownership and making it absolutely understandable that owners had this responsibility, which led to a concept of standard of care, and ultimately making a legal responsibility to have these standards and to undertake standard of care at all levels, from the owner to the major operators to the managers of the operation, right through the whole system, and ultimately to the safe water delivered to the public. So I think those were the key ones, and subsequently to that, the legislation that came out included a number of those elements. I think there was other important parts, but overarching, I think those things were really missing and were fundamental to the breakdown of what ultimately happened at Walkerton.
Mm-hmm, mm-hmm. And those are in place now, and they're important pieces of the system now for protecting drinking water.
That's right, yeah.
Mm-hmm. Yeah. So you then wore yet another hat before this was all done, and you became the first chair of the Ontario Drinking Water Advisory Council. And that council provides independent advice to the Ontario Minister of the Environment about drinking water.
Yeah.
So why did you think it was important to take on that role after the Walkerton Inquiry?
Well, that was another surprise in there. One of the early clauses of the drinking water legislation that came out, I think it was Section 4, in fact, was the creation of this Ontario Drinking Water Advisory Council. And it gets back to the discussions with developing the Part 2 report. And that was a sense that came out of the process that ministers weren't being well advised or well informed of what was going on. And again, back to understanding roles and responsibilities. So it became very clear that the creation of this council and the purpose was to have a direct line to a minister without being filtered by ministry staff or other governmental processes, to support the minister and give them direct and independent advice on all policy matters and standards with respect to drinking water. So that role really intrigued me, because having worked with the inquiry, that clearly came up, in fact, somewhat jokingly, when I met with Justice O'Connor afterwards. And I know we talked about the council. Justice O'Connor kidded me later on, saying that was it me who put that clause in so that I could run the council afterwards? But no, not true. Interesting enough, though, when they approached me to do that, they had recently just changed governments, and the new government had taken place, and a new minister had come to the Ministry of the Environment. And we as a council were just getting started at that point, and the minister worked with me directly, because it had become quite apparent to Leona Dombrowski that, in fact, she was having that serious problem. She couldn't get the answers to a series of questions in any direct way, and she asked us as the council if we could move quickly on a particular subject, what turned out to be how to address and administer private and small drinking water systems, which had been spoken to in the Part 2 report, but still there wasn't a good practice or process in place to manage and ensure that these systems would be able to provide safe water. And it had been identified by many sources that, in fact, if there could be another serious health problem, it could well come from these these very small and private systems that serve drinking water to the public. So it was a very intriguing role to take on, and it was interesting to have the opportunity for the council to work directly with the minister and the minister's senior policy persons. And again, I think that's where we crossed paths again, Teresa, because you stepped into one of those policy roles for a little while, and we had a chance to work together on some of those drinking water policies and practices. And the council members, there was at any one time 10 or 12 members, were very active. And one of the interesting roles that when I took that on, I made it a requirement that there had to be health practitioners on the council. And one of the missing things all along with the Ministry of Environment and drinking water in particular was the lack of presence of health practitioners. And it was seemed to be an obvious missing link that health people, public health people, were not directly involved in the policy development and review role. So we wanted to make sure the council had those types of people on it. And so we had a broad field of experience and knowledge on that council.
So Jim, do you think we've remembered the lessons of Walkerton today when you think about the last 20 years and what you've observed since then?
Yes, I've given a lot of thought about that, and I think there was a lot of good work done and a really serious effort post Walkerton for 5 to 10 years to try and improve across the province. But subsequently, I've become more aware of I guess I could call it slippage in that people are starting to not pay attention. Councils aren't quite as interested in drinking water, and but I'm sorry to say that even with some of the people who are in the business, some of the younger groups don't seem to be very aware of what happened in Walkerton. They hear Walkerton and know something went on, but there's really not aware of it. When I have asked some of them, have they read the Justice O'Connor's report, the answer is, oh no, they hadn't read it. They didn't know that it was available. So it's kind of sad. At my role with the Drinking Water Advisory Council, we came across 3 potentially very serious incidents that we brought to the attention of the Ministry of the Environment, and they didn't seem to be very aware of them, where in fact the operators had failed to operate the water system, and in fact raw water had got in to the drinking water distribution system in 3 small towns in Ontario. Those were very close calls, and fortunately there didn't seem to be any consequences. But what was most disturbing was the Ministry of the Environment didn't seem to be particularly concerned about using those as cases to follow up and to reinvigorate the fact that dangerous things can still happen, and there's a real strong potential. And what I'm most concerned about when I go to the drinking water conferences for the Ontario Waterworks Association, and I still run across people there who you can catch off guard making comments that if it wasn't for a couple of stupid people in Walkerton, we wouldn't have to be following all these rules, which is pretty sad to continue to hear. So, so I still am concerned that we've got a ways to go to keep this going and keep the momentum going.
Right, because I think one of the big lessons that Justice O'Connor concluded or kind of permeated his report is that it needs a system of protection. And you certainly spent a lot of time educating us as counsel for the Walkerton citizens about the multi-barrier approach and how you need these various protections to make sure that at the end of the day, the actual water we consume is safe. Well, thank you very much, Jim, for agreeing to meet with us today and join us on this series. This interview was one of a short series titled Walkerton's Drinking Water Protection Legacy, curated by Selah and intended to be housed on the Selah Foundation's environmental history pages. In this series, we focus on the essential lessons learned from one of the significant Selah cases, the Walkerton Inquiry, and how to ensure drinking water protection and environmental protection is safeguarded into the future. Jim Merrit was an advisor to the Selah legal team and the concerned Walkerton citizens during the inquiry, as well as an advisor to Mr. Justice O'Connor, who led the inquiry during its second phase. And he was the first chair of the Ontario Drinking Water Advisory Council. Jim, thank you so much for joining us today.
Good, thank you very much for inviting me.